evidence is listed.
It is in the body. Yes. Schedule 14.
क्या है लिस्ट?
Execution proceeding चल रहा है और टाइम वीकली टाइम देने की सुविधा है तो ये
कितना डिले?
187 days का डिले सेकंड से कंसल्ट किए थे 187 days का इसमें तो 20 फाइल करने के लिए बोला गया था इसको यस
3:30 बजे आएंगे। 3:30 बजे आ जाएंगे।
Password case from 10:30 daily, pattern 22 to 24, along with pattern 12.
तो फोकस नहीं आएगा तो कैसे?
पासवर्ड कैसे
क्या करना? कल के लिए करना चाहिए। The superintendent of police of the concerned district and the concerned IU appeared before this court. However, the concerned IU has not filed any show-cause / explanation with respect to the order dated 6/5/2026. So far as the Superintendent of Police Jharkhand is concerned, he has submitted that a show-cause notice has been issued to the IU of the case, to which he is yet to post this case tomorrow for filing of the show-cause of the copy number of the IU of the case, who shall remain present tomorrow also. So far as the SP of the concerned district is concerned, his appearance is hereby dispensed.
day after tomorrow mirror
नहीं हो सकता है यार tomorrow. इसीलिए IU फॉर्म्स there is a detailed notice.
इसमें मैंने केवल
और
अगला 52 से 65 तक केवल अपने से डायरी दे ली है जिसमें लेकिन के बारे में बात होता केवल डायरी अपने से लिखी है उसके बाद
Item password is item 39 along with item 40.
Case diary and criminal antecedent report was called for. Recovery of one mobile in PA number 2421, that is Samir Ansari. And according to my
आज नहीं हो सकता. The other side is not there. Post tomorrow. नहीं होगा, cyber crime वाला cases नहीं होगा. Because both the sides could have been there, it could have been taken out. जितना भी cases है सब कल के लिए. जितना भी पास होगा देखिए जितने भी हैं जितने भी बचे हैं कल रहेगा सप्लीमेंट्री लिस्ट. First I will take up the supplementary list and then I will take up the main list. Main list में 24 cases हैं.
that's it. Obligation.
From date list for hearing item 1, 1st April 94 of 2026.
In this case, I will assist your lordship on behalf of the respondent. I was praying for a short accommodation. If your lordship may kindly take up this case tomorrow or day after tomorrow. I was engaged in this case only yesterday evening.
We can't do anything about it. Why do you have to give your, it's a first case.
Yes, that's
So, the first case, what would we do? I give you time to respond. You listen to his argument.
okay.
Fair enough?
Yes.
Yes, please.
This is related to the new land acquisition, where the award was prepared in the name of both male and female heirs. The dispute is we are for the male heirs. We dispute the entitlement of the female heirs of the original recorded deed. That is the crux of the matter. Now, my basic submission would be that the trial
So
court
record with me. Record. Yes, please.
it has solely relied on a Supreme Court judgment and it has rejected my claim. It has rejected my claim relying on a Supreme Court judgment, absolutely misapplication of the
Which is
judgment.
that Supreme Court judgment?
Yes, that it has quoted in the judgment itself, but I'll give a copy. It has quoted the entire judgment. Running page 18, it quotes para 10. Para 10 is the bottom. In view of the above discussed fact, I would like to rely upon the judgment passed by Honorable Apex Court in the matter of Ram Charan and others so and so, wherein on similar situated fact, the same question had come before the Honorable Apex Court that whether a tribal woman on her legal heirs would be entitled to an equal share of her ancestral property or not. In the said case, a claim of appellant plaintiff Ram Charan was denied in a partition suit up to the Honorable High Court of Chhattisgarh, Bilaspur, brought by one Daiya, a woman belonging to the scheduled tribe, who had filed the said partition suit for partition of her property belonging to her father, by holding that is the maternal grandfather of the appellant plaintiff Ram Charan and others, by holding that in absence of any proof of custom in tribes in a suit between the parties, the Honorable Court had been pleased to hold that. And then it quotes.
Did you plead and prove the?
Yes. This is the reason I say that the trial court does not discuss anything whatsoever.
We are going to discuss it.
Yes, I'll show that.
Show
It has,
the pleading and proof of custody.
yes, I'll show. First, the judgment itself it mentions as to what has been pleaded and proved. That portion I'll show and then I'll come to the.
You belong to which tribe?
If you could kindly come to page 16 where the finding starts at page 5, para 5.
Just a minute. The award was prepared in whose name?
In the name of all the heirs of the.
Including the doctor.
Yes. Our name and the.
It was picked up from the record of rights or how?
From record.
From record of rights. So they were shown in joint possession.
No, it was in the name of ancestors of
That's
the.
right.
both
But in the
the-
record of rights, it was shown in joint possession.
Yes,
Right? Both the parties.
of the ancestors of the party.
When did the
Obviously, ancestor of the female descendant also.
when was the immediate ancestor of the female descendant died? And when was this entry was made in the record of rights?
This was in 19. This is related to Ranchi.
Yes.
1935.
1935.
Yes.
So this entry continued since 1935.
Yes.
These ladies also remained in possession. As
No,
per the
because-
records, as
No,
per the record of rights.
Because it was in the name of ancestor of the party.
That's right. In the name of ancestor of the parties, it's okay. But there was some entry of these parties also.
No,
The
no,
record of rights.
It was only in the name of ancestors of the party.
That was entered in 1930.
Yes.
And what was your to which caste do you belong?
Munda.
Let us see the case of respective parties. Paraku.
I was replacing the finding portion, which is at page para 5.
You read Paraku.
Para 2.
Let's see the case of the respective parties has been mentioned.
Yes, yes.
You read that.
I'm skipping the minute details
Yes.
of the properties that have been mentioned.
That's right.
That is there in
That
para.
you can skip. Those are all admitted facts.
Yes. Para 2 I am reading. The petitioner claimants have raised their grievances before the authorities concerned DLAO and claim that the petitioners and the opposite parties are by caste Munda, being members of the scheduled tribe and are governed by their customary law in the matter of succession and inheritance. According to the customary law prevalent amongst the Munda community, if a male Munda dies, leaving behind no male issue, his widow and unmarried daughters are entitled to be maintained out of usufruct of the immovable properties left by the last sonless Munda, so long as the widow does not remarry, and if she does not marry, so long as she is alive, and so long the unmarried daughters are not married, and if they are not married, so long as they are alive, and after remarriage of the widow, and after her death, as the case may be, and after the marriage of the unmarried daughters, if they die in unmarried, the property of the last male sonless Munda devolves upon his nearest male acne. The petitioners are the settled rayats of village Sukurudu, Rachi, so wherein the petitioners have their ancestral rayati land in divisional survey number so and all the land details I am skipping. Then last 5 lines. All these were recorded in divisional survey record of right in the name of Sauna Munda, Bhagwa Munda and Indua Munda, sons of Suma Munda, and they were in possession of the same. After the divisional survey, Bhagwa Munda died issueless, and as such, according to the customary law prevalent among the Munda community, his interest in the land of the aforementioned Khatas devolved upon his full brother Sauna Munda and Indua Munda, who came in joint possession thereof. Sauna Munda died, leaving behind 2 sons, namely Bandhan Munda and Langa Munda, out of whom Langa Munda died, leaving behind no male issue. And as such, according to the customary law prevalent amongst the Munda community, his interest in the land of the aforementioned Khatas devolved upon his full blood brother Bandhan Munda, who came into possession thereof. Bandhan Munda died, leaving behind 3 sons, namely Chaman Munda, Kaila Munda, and Sanicharva Munda, who inherited the interest of their deceased father in the aforementioned land and came into joint possession thereof. Chaman Munda died, leaving behind his only son Ganju Munda, since deceased, who inherited the interest of his deceased father in the aforementioned land and came into possession. Gahna Munda died during the pendency of the above case, leaving behind his widow Udhan Devi, petitioner number 1, his son Radha Munda, petitioner number 1A, unmarried daughter so and so. All these were substituted during the pendency of the suit. Therefore, 1A, 1B, and 1C, who inherited the interest of the deceased Gahnu Munda and came into joint possession thereof and are still continuing possession of the same.
On the one hand, you see that the widow and their daughters, etc., have no right, but on the other hand, you say that they inherited the properties.
They have been substituted during the pendency of the.
But according to you, you say, as per this, what has been recorded here, that these ladies, they inherited the property.
No substitution was made. All these statements were there with regard to the original plaintiff number 1 itself, who was during the pendency was substituted. That is there. I cannot change this.
So in the prayer for substitution, you must have said, no, there has to be a substitution petition.
Yes.
In substitution petition, you must have said that they are the legal heirs, they
Legal
have
heirs
inherited
and
the property.
successors, it must have.
Yes.
That petition is not there, but I do get that one.
Yes. You see?
Pehla Munda died leaving behind his only son Chotan Munda, who also died leaving behind his widow Muni Devi, petitioner number 2. Sanicharva Munda died leaving behind his 2 sons, namely Sitaram Munda and Etwa Munda, petitioner number 3 and 4 respectively, who inherited the interest of their deceased father in the aforementioned land and came into possession thereof. The recorded prayer, Idwa Munda died leaving behind his only son Budwa Munda, who inherited the interest of his deceased father in the aforementioned land and came into possession thereof. Budwa Munda died leaving behind no male issue except his daughter Daho Devi, opposite party number 1. And as such, according to the customary law prevalent among the Munda community, his interest in the land of the aforementioned father devolved upon his dearest male agnates, that is, upon the surviving legal heirs of late Sauna Munda, including the petitioners, and they are coming in peaceful possession. The petitioners have absolute right, title, interest, and possession, share, and manner of concern with respect to the acquired land, and they are entitled to receive the compensation amount of the award published in the name of Sauna Munda and others. It is submitted that the claim of the opposite party, Daho Devi, daughter of late Purva Munda, and Mohan Munda, opposite party now dead, son of late Birsa Munda, who have filed objection and are claimed that they are the legal heirs and successors of the recorded tenant, are absolutely false, frivolous, vexatious, and not maintainable in the eye. Now here is the main statement of us. Daho Devi, daughter of Purva Munda, was married to Shivdawal Munda since deceased and is residing in her in-laws' house since the time of her marriage, and according to the customary law prevalent amongst Munda community, a married daughter does not inherit the property left by her deceased sonless father, and as such, after the death of Purva Munda, his interest in the property left by him, including the property acquired under land acquisition case number so and so, and as such is not entitled to receive any compensation with respect to the acquired land. So far as the claim of Mohan Munda now dead is concerned, he is the maternal grandson of Rangda Munda, who died leaving behind no male issue. Subro Devi was daughter of late Rangda Munda, who was married with Birsa Munda, and since after her marriage she was residing in her in-laws' place and died leaving behind her son Mohan Munda, opposite party now dead. Subro did not inherit the interest of her deceased father in the aforementioned land, as he died leaving behind no male issue, and according to the customary law prevalent among the Munda community, and after the death of sonless Munda, male Munda, his property devolves upon his nearest male agnates. The parties are following Sarna religion and they are following their customary law till today. It is further submitted that in the above case, both the parties have used oral evidence. So far as objectors are concerned, they have examined altogether 5 witnesses, and from the oral and as well as documentary evidence, it is sufficiently established that the petitioners are the surviving male descendants of the recorded tenants Sauna Munda and others. The petitioners have absolute right, title, and possession over the land of Khata number so and so, village Sukurutu, PS Sukurutu, district Ranchi, and they are entitled to get the award prepared in their name and to receive the compensation money. On the other hand, from the oral evidence, it is proved that the objectors are the female descendants of the recorded layer, and according to the customary law prevalent among the Munda community, the female heirs are excluded from inheritance of the ancestral property. According to the decision reported in 1996, so and so, the provisions of Hindu Succession Act and so and so Succession Act 1925 did not apply to scheduled tribe. The general principles contained therein being consistent with justice, equity, fairness, justice and good conscience would apply to them. Neither Hindu Succession Act nor Succession Act nor even Sharia law is applicable to the custom governed in the matter of tribe. Further, in decision reported in so and so Jharkhand, it has been held that a customary law of tribal people, if a person dies without male issue, the widow and unmarried daughter hold the properties of her husband / father in lieu of her maintenance, and they have no power to alienate the property by sale or gift. The Honorable Court in decision reported in 1968 PLR 215 has held that the tribal customary law of inheritance governing the Munda is that the widow of Munda gets a life interest in the property left by the husband and no power to alienate by sale or gift. Further, the Honorable High Court of Jharkhand in decision reported in 2022 so and so has held that in every case the claim of title is to be decided on the pleading and proof of customary law regarding prevailing custom. Ideally, it is high time that a customary law of succession should be codified and it should be given a statutory shape. But in the meantime, each case has to be judged individually regarding the applicable custom. To the same effect, in the decision of Honorable Supreme Court in the case of so and so, thus it must be held that the petitioners are legal heirs and successors of the recorded rayats of Khata number 447, 448 and 519 of namely Sauna Munda and others, and they are entitled to get the award prepared in their names with respect to the land under proceeding, and they are entitled to receive the compensation money. It must be further be held that the objectors, being the female descendants of the recorded rayat, are not entitled to inherit the land of the said, and they are not entitled to receive the compensation for the acquisition of the lands under proceeding. It is pertinent to mention here that the portion of the land of Divisional Survey Khata number so and so have been acquired for the project of ITBP headquarter establishment by land acquisition case number so and so, and the awards. This is a separate, and the awards were
Let
prepared.
us see, you come to the next question.
Yeah.
The case of the victim.
Para 4, the opposite party's case.
Yes, yes.
They, in page 14, para 4, it starts, description of land is mentioned, and then next page. The above said plot of land of Khata number above Khata stand in the name of Khatyani Rayat, namely Sauna Munda, now deceased, Bhagwa Munda, now deceased, Indra Munda, now deceased, which is situated in Moja Sukuruta, so and so, district Ranchi. Sauna Munda, whose Khatyani Rayat died living behind his two sons, namely Bandhan Munda and late Launa Munda, who were the legal heirs and representatives, and after their death, their heirs inherit the same, which is mentioned in their genealogical table. Late Bhagwa Munda, who was the Khatyani Rayat, died issueless, and as such his share will equally be shared other two Khatyani Rayat, namely Sauna Munda and Indra Munda, that is 103 decimals each of total acquired land, 207 decimals. And after their death, their heirs equally share according as per their share. The genealogical table annexed with their petition. Late Indra Munda died leaving behind only one son, namely Bhagwa Munda, who was the legal heir and successor. And after his death, his only daughter, namely Dahu Devi, opposite party number 1, inherited the same, and her share is as per genealogical table annexed with their petition. The opposite party number 2, Mohan Munda, now dead, son of Sukru Devi, daughter of late Nanga Munda, inherited the above said land, and after the death of his mother Sukru Devi, as she was the only daughter of late Nanga Munda and the opposite party number 2 Numan Munda, entitled for half share that is 51.75 decimal amongst heirs of late Nandan Munda.
There is a evidence of invoiced, right?
Yes, this claim has been made by them.
That's supported by the evidence.
No, what? This is the problem. Now they need evidence. They take a plea that they had sufficiently invoiced. We say that we remained Munda and customary laws were being followed. There was absolute two separate cases which were pleaded by the parties. The appellate court, if the honorable court would kindly come to the finding portion in para 5, it takes note in page 17, that portion may kindly be seen.
Yes, I'm there.
Yes, it mentions what were these 5-6 claimant witnesses were examined and their evidences were that has been taken note of. I may be allowed to read that portion. The gist of all the oral evidences of petitioner's claimant witnesses that they have only supported the claim of petitioner claimant and denied the case of the opposite parties and stated that both the parties belong to Munda community and are scheduled tribe and they are guided by Sangla religion and as per custom of Munda community they follow rituals of the said community and as per custom the widow women and daughters have no right to inherit inheritance except for the maintenance till lifetime, remarry, marry as the case may be and stated it is not true that they follow rituals of Hindu religion. Now, the quote below, it also mentions in para 6 as to what was the evidence that was led by the opposite party. The gist of all the oral evidences of the opposite parties witnesses that they have only supported the claim of opposite parties and denied the claim of petitioner claimant and admitted that both the parties belong to Munda community and are scheduled tribe and they are also related to common ancestor as per genealogy and stated that they follow all rituals of Hindu religion in their festivals like Deepavali, Durga Puja, Ram Navami, Saraswati Mata, Lakshmi, so and so. In their Lakshmi Puja, Shiv and Kali Puja, and their marriage, adoption, funeral, nomination, etc. And they are completely Hinduized. And thus the Hindu Succession Act is applicable in the matter of succession and inheritance. And in support of that contention, they have filed one notarized affidavit showing genealogy between so and so. Now, the appellate court, next para, it says the point for determination in the matter is whether the tribal woman or their legal heirs of so and so are entitled for equal inheritance. And what it does, then the next page is the genealogical table. Para 10, it now says, this is the main fact. Now this was absolutely erroneous in view of the fact that the plea of the respondent was that they had sufficiently Hinduized and the appellate court does not even consider this aspect of the matter as to which was the, whether the parties were following Munda or they had sufficiently Hinduized or not. And whether we had been able to establish our custom of it. No discussion whatsoever. And it relies on a Supreme Court judgment which itself says that Hindu Succession Act is not applicable. So how could the court could have relied on that judgment? So my basic.
So what do you think? There has to
My
be a demand or
yes, this is actually my this was the reason that the court below was required to decide all these important aspects of the matter without discussing.
Evidence now we
And
decided for the first time over here.
The judgment.
Who has passed this judgment?
This judgment itself may be kindly received Ram Charan. Ram Charan, I'll read out. It says that the parties had not been able to prove the custom. This was the ground on which justice.
There is no finding whether they have been able to prove or not able to prove. क्या करें बताइए?
On that count, you not say.
Well, whatever it is, not only this, He has to see the cross examination of the witnesses. What is the line of cross examination? Whether anything stands admitted or it does not stand admitted. How this kind of a judgment can be sustained?
Discussion of evidence is
Whatever is discussed is absolutely
He mentions 4 pages, quotes entire 4 pages. His only finding
the
is
gist of evidence. He has to discuss every evidence. Even if the oral evidence is pitted against oral evidence, but that is also required to be scrutinized and he has to come to a finding. And he has not discussed the documentary evidence. There is no discussion of documentary evidence. Is there any?
documentary evidence is none. So only the khatyans, the relevant khatyans and rent receipts of the land. Nothing.
Who is paying the rent? Who is paying the rent?
we have
They have filed that those khatyan and rent receipts. It is declared.
And since when are they paying the rent? Since when have you been paying the rent?
we are paying rent
Since when?
since
These 3 rent receipts
Yes,
are of
sir.
what period?
we have brought 4 rent receipts which have been marked as exhibit 2 to 2/3.
Yes.
But right throughout our cases that we are the persons who are continuously paying. And they have not filed any rent receipt whatsoever. This is also not discussed by the trial. The judgment of the Honorable Supreme Court was based on the fact that there was no custom was proved. This was the essential distinction point.
क्या बोलते हैं इसका टाइम लेके क्या करेंगे क्या नया चीज आने वाला है इसमें?
That's the trial court solely relied on the judgment of Ramcharan and Subram. In that judgment, the Honorable Apex Court has been pleased to hold that in absence of proof of custom or any law governing the succession and inheritance in the community, the course adopted is to apply the principle of justice, equity, and fair play, good conscience. That is
In absence of custom.
if the custom is not true, and if the community involved, there is no law relating, because subsection 2 of the Hindu Succession Act says that tribals are excluded from its application. So in that view of the matter, it was said that your office may kindly have a look
Yeah.
that portion of the judgment. If your lordship may kindly come to page 13 of the judgment. Page 21, running page 21, your lordship. Page 21, para 15, pillars. Given the above situation that neither any particular law of a community nor custom would be brought into application by either side, we now proceed to examine the argument advanced before the High Court, that is the principle of justice, equity, and good conscience. These principles find statutory recognition in the Central Provinces Laws Act 1875, Section 6, whereof is extracted herein, in cases not provided for by Section 5 or by rule, in cases any other law for the time being in force, the courts shall act according to justice, equity, and good conscience. And taking the recourse of this provision of law, the
Next para also we will see.
that
Otherwise, because that was noted by that act has also been repealed.
that repeal, but whatever rights had accrued before it, the repeal of that act is saved by the saving clause. That is also mentioned in
Which act? Which act?
you know,
Which act? I was in some other page.
sorry.
I was looking at some. So you are referring to the judgment which has been quoted.
Yes, of the honorable.
That is 2005 amendment.
No, it is 25. 2025 judgment. Ram Charan.
Yes, it is there. What were you saying about the amendment? Which amendment are you talking?
Amendment I will not submitting because I was referring paragraph 15, page 21, running page 21.
Yes.
That is the extract of the judgment of the Honorable Apex Court in the case of Ram Charan and Sutram. May I please? Para 15, given the above situation that neither any particular law of a community nor custom could be brought into application by either side, we now proceed to examine the argument advanced before the High Court, that is the principle of justice, equity, and good conscience. These principles find statutory recognition in the Central Provinces Laws Act 1875, Section 6, whereof is extracted herein below. In cases not provided for by Section 5 or by rule, in cases any other law for the time being in force, the court.
Let's say we have got.
So on that premise, the Honorable Apex Court was pleased to hold that taking the course of this provision of law, it was decided that the female descendants are also entitled to share it.
The court has not recorded two things.
And
One is, court has not recorded that there is no evidence.
it has not discussed
Evidence can be oral or documented.
document.
So there is no finding that there is no evidence. The court has said that this is the evidence of plaintiff, this is the evidence of defendant, and they have supported each other, but no independent finding.
That generalized,
Not generalized, it is.
The evidences of all the witnesses have been generalized in one paragraph. That is not the case. Every witness has said something different, and that should have been discussed. That is clear. The trial court was probably guided by the fact that that the appellants were not able to prove the custom, and on that count he took the recourse of the Honorable Supreme Court judgment. But certainly it should have discussed the evidence.
Not a single line that failed to prove the custom. Chairman, conclude with 2 lines of this.
Yes, yes.
I'll conclude. I'll not waste the honorable courts. The first is that we brought into evidence, oral evidences that there was a custom under which the females were not entitled to inherit the property. And that has been quoted by the trial court also. But it does not give any finding whatsoever that we have failed to prove or what is the custom we were unable to prove. It does not whisper a single lie. On the other hand, the defendants themselves took a plea that they were guided, they were sufficiently Hinduized, and therefore they were entitled. Although being tribals, they take a plea that they had sufficiently Hinduized, which was absolutely against the judgment quoted by the appellate trial. In the trial court itself, in Ramcharan itself,
There is a concept of sufficiently Hinduized.
Yes.
there is concept, but in this judgment itself, what the Honorable Supreme Court says that once you are a tribal, then you cannot take shelter of. There are 2 kinds.
That judgment
There
may
was-
not apply technically. Because we have judgments of sufficiently
Yes,
Hinduized Munda.
There.
So
But
that
here,
judgment will not apply.
but here is a case where the Honorable Court says that even because there are 2 cases which were decided by the Honorable Court, Supreme Court, similar set of where the parties had taken a plea that they were Hindus, they had adopted, they were Hindus, and therefore they were no longer tribal, and therefore Hindu
So
law.
here also they have taken a plea that they were Hinduized, they were
Yes.
following the Hindu
But
religion.
in this case, this particular plea was rejected by the Honorable Supreme Court. Therefore, there are 2 cases where, although in earlier point of time there have been a case where
And
the
there is a
Labishwar Maji
consistent
and
view
others
of our court that if the tribe is sufficiently Hinduized, if they are able to prove it, then under such circumstances, that plea that they will be governed by the Hindu law will be taken into consideration.
But
But
here,
the point is there is no discussion.
no discussion.
There is no discussion.
No, absolutely. No discussion whatsoever. So in either of the cases there was no discussion. And the decision or the judgment passed by the trial court.
I just want to know one thing. Who was the objector? You were the objector or the ladies were the objector? To the award.
We were there.
You were the objector?
Yes. We had finally
Okay. So award was prepared jointly with you.
jointly.
We find it from the record one document. There is an affidavit saying that these are the customs, these are the instances to show that they are sufficiently utilized.
It is their affidavit. So can an affidavit be treated
No,
as
it is not their affidavit. There is something more to it. It says, see, this is being signed by Mukhiya and many others.
but Mukhiya was required to be examined and he would prove.
Who is the Mukhiya? What is his name? He has been examined. Also, oral witness is there.
Yes, oral witnesses are there. There are altogether 6.
6 from either side.
Yes, he is OP witness number 1. Manoj Gupta.
OP number 1. इसका और भी रिकॉर्डिंग
ये एक मिनट, नहीं वो नहीं है, ये तो इनका ओरल एविडेंसेस का ये एविडेंस नोट है. That affidavit I don't have. I don't think that there would be any affidavit because only 4 documents were exhibited on our side and they had not filed any documentary evidence.
But affidavits of the witnesses
Affidavit of witnesses were.
witnesses have been examined on behalf of both the particulars and they have been cross-examined as well.
There is mention of one letter by circle officer which was forwarded to the land acquisition officer that is mentioned in running page 18. That he had submitted a report verification.
There are ample evidence on the record that suggests that the opposing party responded were sufficiently well because in their affidavits as a witness they have stated each and everything about their invitation.
Plaintiff की दफा कौन-कौन? Plaintiff has been examined. आपकी तरफ से कौन-कौन दफा?
Muni Devi is one witness.
कौन है?
Muni Devi, CW5.
So who is she? Is she the claimant?
Yes. Ah.
सरना धर्म बोल के क्या होता है?
क्या?
There is no सरना धर्म. Is there any?
हाँ, सरना होगा ना.
सरना धर्म बोल के तो कोई हम सुने नहीं. सरना धर्म कोर्ट की बात चल रही है, लेकिन ऐसा कोई सरना
नहीं,
धर्म
Sarna is a way of worship by the tribals. That is called Shikha.
Where do we get this?
And all the members of scheduled tribe, their original religion is Sarna. Scheduled tribe word is a race, whereas Sarna would be religion. CW3 to CW6, all these are trimmed. Idwa Munda, Sitaram Munda, Mundi Devi, and Radha Munda. Relevant portion of Supreme Court judgment I would be allowed to place.
क्या करें? कोई डिमांड कर दें, क्या करें?
So after reporting our submissions to
आपका क्या सबमिशन है?
my submissions are notes that it was the applicants who had the onus to prove that there was custom that female descendants will not inherit the property, that they have felt it in
How
proving
they
that.
have failed?
Lots,
When you make a submission, you have to substantiate also. How do you have to fail?
lots,
क्या उनको प्रूव करना है? मतलब क्या एविडेंस से वो प्रूव करना है?
by giving instances that ऐसा ऐसा हुआ था हमारे community में इस तरह से
No instances has been.
no instances have
Only
been
oral that this
Oh.
happens and this
This
happens. And
happens
this.
only this is there, and secondly, my lords, there are ample evidence on the record that the respondent has sufficiently been invited, and on that count also they are entitled to inheritance property. There will be application of Hindu Succession Act in so far as they are concerned, if they are sufficiently invited. So, in our submission, lords, there is ample evidence on this count. If your lordship may kindly have
Is
a
there
look.
any discussion?
There is no discussion. That is the whole difficulty. Otherwise, there is evidence to that effect. Taho Devi, the respondent, she has
तो इस ग्राउंड पे डिमांड तो नहीं कर सकते बताइए क्या करना है आपको
नहीं,
चाहिए?
demand to
Demand तो
actually this is a ground for demand for reason that both the parties are claiming separate have proved. I have proved or I have pleaded.
you say that this is the ground for demand.
Yes.
But the Supreme Court says that when all the evidences and materials are there on record, why should there be a remand at all?
Because the
Because first appeal
essential
is an extension of
हो
trial.
सकता है उसमें, but this was a case where it does not say that the High Court has to hear when the entire evidences are there. It does not say so. It only says that remand should be avoided. This is the only.
That's right. Remand should be
So
avoided.
here is a case where both the parties have dead evidences and the trial court's judgment is solely based on that on a Supreme Court judgment which does not apply in this case. Because the trial courts, I'll just read para 10, it discusses what is the Ramcharan case, and then in running page 19, last two lines, it has quoted in 19, wherein on similar situated fact the same question had come up before the Honorable Apex Court that whether a tribal woman or her legal heirs would be entitled to an equal share on her ancestral property or not. In the said case, a claim of the appellant Ramcharan was denied in a partition suit up to Honorable High Court of Chhattisgarh, Bilaspur, brought by one Bhaiya, a woman belonging to scheduled tribe, who had filed the partition suit for partition of the property belonging to her father, so and so. By holding that in absence of any proof or custom in tribes in suit between the parties, the Honorable Court has been pleased to. So this was the distinguishing factor, which based on this he could not have relied on the same argument. It was not a case where the parties have not proved any custom. Both were proving some other custom. He said that we are Hinduized. We said that there is a custom, original custom which we have proved. And proof also means that there was no compulsion to prove a particular fact only by way of a documentary evidence. We had given 6 witnesses, out of whom 4 were the plaintiff claimant themselves, 2 were outsiders. Similarly, they had also given witnesses. The appellate court does not even discuss any of those, and it relies then para 12 of the same page, page 19, para 12, where the Supreme Court judgment is quoted. In page 19, para 12. Thus, from the analysis of the above evidence, it is made clear that the plaintiff has not made the statement of even any witness for proving their custom. In para 12, this is the quoted portion of para 12. Page 19. Plaintiff has not made the statement of even any witness for providing their custom, but it would be proving their custom. Apart from this, they have also not made the claim of the fact governing their custom from the caste tradition and their contentions. And then next page may kindly receive para 13 of the same quoted government. Since the Hindu law has no application, the next possibility to be considered is whether the application to custom. For that application of a custom to be shown, it has to be proved, but it was not in the present case. Then next page, para 15. Given the above situation that neither any particular law of a community nor custom could be brought into application by either side, we now proceed to examine the argument advanced before the High Court, that principles of justice, equity and good conduct. And then concluding paragraph would be para 28 of the same judgment. Granted
If
that
there are conflicting, like there is a consistent oral evidence from the side of the plaintiff that they are governed by customary,
yes,
and this has been recorded by the learned court also. And at the same time, there is consistent oral evidence from the side of the defendant that they are Hindus. Then, under such circumstances, what is the court supposed to do? The evidences are consistent.
no, but the court has to see as to whether if the the sufficiently invoiced concept is taken, then the court has to see as to whether actually they had sufficiently invoiced or not. This adjudication has to be there. Without that adjudication, because there would be rival contention of the parties, rival evidences, then the court has to find out which of the evidences are true, whether they have actually sufficiently invoiced or not. So if they have sufficiently invoiced, unless that is pleaded and proved, then that judgment cannot have any application. There cannot be any case that where there are rival cases where we say that we are following Sarna, but they say that all the parties have now sufficiently invoiced, then only they will be getting that. If we are able to prove that there was a custom which
From your side, all the family members were examined or independent witnesses were also?
it appears that two claimants are there, four claimants are there, claimant witnesses are. Claimant witness
Who is
number one,
Abdul
Abdul
Munda?
Munda
Who
is.
is Abdul Munda?
Yes, that is what he says that मैं आवेदकगण को विपक्षीगण को जानता हूँ, इस बात में दोनों पक्ष सरना धर्म को मानते हैं या कि आवेदकगण विपक्षीगण मुंडा समाज के सदस्य हैं. He is a third party. He is a third party who is a villager, aged about 65 years, who has come to the courts.
He is the cousin brother of applicant Raham. He is admitted in para 9 of the cross-examination.
And one more important factor would be there. The moment they take a plea that they have sufficiently invoiced, then they are not denying the custom. They are only escaping the customary law on the ground that they have sufficiently invoiced. Otherwise, they impliedly admit that the custom, if custom is applied, then they are debarred from inheriting the.
You see, it is one thing to say that they are governed by customary law, and it is another thing to say that under a particular system, under a particular custom, the females are debarred from inheritance. So you say that in the plaint it is written that under a particular custom the females are debarred from inheriting. The fact that under the custom the female is debarred is not in dispute. What the defendant has taken a case that since they were sufficiently invoiced, they will be governed by the
Exactly, this is my submission. Because they have.
And therefore it was for them to prove that they were sufficiently
Exactly,
influenced.
this is my.
Which they have proved.
No, but the appellate court does not say so.
The
So here
The trial-
they have only led evidences. Now whether they have proved or not, this is what.
This would require scrutiny of evidence.
Yes.
Which has not been done by them.
Yes. Because we have led separate
You
evidence.
see, there is one more reason why I want this matter to be remanded. Because now you know the contours of the matter. There is also a possibility of adducing additional evidence, if anybody wants. See, in order to, in such kind of cases, the parties are actually not well advised. So, both of you can also prove by saying that you just see in our community such and such person was given partition or any judicial pronouncement with respect to a particular party, that ultimately the property was handed over, was given to the lady as by inheritance. They would also have an opportunity to prove by way of what is happening in their society. It's not that property is not there. Property is certainly passing hands. But those evidences have not been proven. So I don't want to say that one should give or one can give. But at this stage, how do we decide?
Yes, my submission would be that if pleading on our behalf was that we were sufficiently involved, and there are ample evidence to that effect.
They have also laid oral evidence that they are following sadhana. And in the cross-examination, they are denying that they are not Hindus. And rather, they are giving instances as to what kind of ritual was followed when the people die in the family. That is there.
Yes, but see, if your lordship may kindly have a look to the evidence of the respondent, Daho Devi. Daho Devi, she says in her affidavit, यह कि मैं भूअर्जनवाद संख्या 2021 की प्रतिवादी हूँ कि मैं और मेरे परिवार के लोग हिंदू रीति रिवाज को मानते हैं, यह कि मैं और मेरे परिवार के लोग होली, दिवाली, रामनवमी, दशहरा इत्यादि मनाते हैं, यह कि मेरे परिवार में किसी की विवाह होने पर मंडप में वर वधू 7 फेरे लेते हैं, यह कि मेरे परिवार में किसी की मृत्यु होने पर शव को जलाते हैं एवं दशकर्म करते हैं, यह कि मेरे परिवार में किसी विवाहित पुरुष की मृत्यु होने पर ही उनकी विधवा महिला सिंदूर धारण नहीं करती है, सिर्फ पति के जीवित रहने पर ही महिला सिंदूर धारण करती है, यह कि मेरे परिवार के सदस्यों का हिंदू नाम रखते हैं जैसे शिवदयाल मुंडा, मोहन मुंडा, सीताराम मुंडा, मुन्नी देवी एक्सेट्रा. तो लवीश्वर माझी केस इज फुल्ली एप्लीकेबल इन आवर केस. दैट कवर्स आवर केस. और क्रॉस एग्जामिनेशन में भी ऐसा कुछ नहीं आया है कि इनवाइलेशन उनका नहीं उनका बहुत अच्छा खासा लेंथी क्रॉस एग्जामिनेशन हुआ है. कई परमिट आई विल प्लेस दिस इन क्रॉस एग्जामिनेशन पार्ट ऑफ द एविडेंस. दाहो देवी.
She is witness number.
विटनेस नंबर की
नहीं है 2 कॉपी विटनेस नंबर.
जो जजमेंट से लेकिन एफिडेविट में कोई नहीं है.
कि मेरे परिवार मतलब वेदर आर मैट्रिमोनियल होम और एवरीवन.
This is too long term. So this. क्रॉस एग्जामिनेशन पढ़िए।
Yes. मैं हिंदी पढ़ना लिखना नहीं जानती हूँ। मेरे पिता का नाम बुधवा मुंडा था। मैं अपने पिता बुधवा मुंडा का एकमात्र संतान। मेरे अलावे मेरे पिता बुधवा मुंडा की 3 पुत्रियां करनी, बंदरिया और रतवा हैं जो यहाँ नहीं रहती हैं। यह सब अपने अपने ससुराल में रहती हैं। मेरी शादी ग्राम गांधी, थाना कांके, जिला रांची में हुई है। मेरे पति शिवदयाल मुंडा की मृत्यु हो गई है। मेरे पति का देहांत कब हुआ था मैं नहीं बता सकती हूँ। मेरी शादी हिंदू रीति रिवाज से हुई थी। मेरे ससुराल वाले हिंदू धर्म मानते हैं। मेरे पति की मृत्यु के पश्चात मसना सुकुरुकु में मिट्टी दिया गया।
Just hold on. This is very important. One of the most important rituals of Hindus is funeral.
ये दाह संस्कार।
दाह संस्कार। ठीक है। यह कि मेरे परिवार में किसी की मृत्यु होने पर शव को जलाते हैं एवं दशकर्म करते हैं। राइट? पैरा 5। और यहाँ क्या बोल रही है? मेरे पति की मृत्यु के बाद मसना सुकुरुकु में मिट्टी दिया गया था। आगे पढ़ी।
मेरे पति का मेरे ससुराल में जमीन जायदाद है। उसका हिस्सा बंटवारा अभी तक नहीं हुआ है। गागी में मेरी एक दुकान है जो मेरा बेटा चलाता है। गागी में मैं जमीन में बोरिंग नहीं कराई। जब से मेरी शादी हुई है तब से मैं अपने मायके में रह रही हूँ। गागी में मैं कभी नहीं रही हूँ। केवल मैं ही अपने पिता की संपत्ति में दावा कर रही हूँ। दावा करने के पूर्व मैं अपीलकर्ता गण के विरुद्ध बंटवारा का मुकदमा नहीं की थी।
ये अपने फादर के प्रॉपर्टी में he is claiming right.
Yes.
He is claiming right.
Yes.
सर क्या मतलब?
Yes, he is claiming right.
लेकिन कुछ ने लिखा है कि उसका भाई है कि नहीं है?
भाई तो नहीं है, वो तो मेरे
इकलौती बेटी।
नहीं, इकलौती बेटी थी, लेकिन साथ में सेकंड पैराग्राफ में कह रहे हैं कि बुधवा मुंडा मेरे पिता की 3 पुत्रियां करनी, बंदरिया और रतवा जो यहाँ नहीं रहती, वो सब अपने अपने ससुराल में रहती हैं। ये भी अपने एविडेंस में कह रही है। तो दावा करने के पूर्व में अपील करता गण के
मेरे पिता की मृत्यु के बाद उनको गाड़ी में दफनाया गया था।
पुनः
कहती है कि जलाया गया था।
मेरे पिता
17
मुझे जानकारी बहुत दिन हो गया। मेरे पिता की मृत्यु के बाद उनको गाड़ी में
उनके घर में मिट्टी दिया गया,
जलाया गया।
गहनू मुंडा की मृत्यु के पश्चात उसका दाह संस्कार सुकुरुटी मसना में किया गया। Funeral is a very, very important custom.
That is
Absolutely inherent in Hindu religion. Hindu religion में दफनाया जाता है सिर्फ बच्चों। Yes. Minor things.
But custom part अगर देखा जाए तो custom जो है तो इन लोग
देखिए, the entire case was. It is not in dispute that they belong to tribal community.
that is not in this.
The defendants claim that they are sufficiently Hindus. Firstly, once they are admitting that they are otherwise governed by custom, and if they claim that there is a deviation, who has to prove it? The defendant has to prove it, that they have deviated from the custom. Correct? Now, in order to prove that they are deviated from the custom, all the instances of Hindu religion has been enumerated. And I think this enumeration is there in all the evidence, same to same, एकदम copy paste है। हम एक और भी देख रहे थे, इसी तरह से एकदम exactly।
मोहन मुंडा।
हाँ, सबका उसी तरह से मोहन मुंडा का भी आप देखिए, ठीक है। उसके बाद इनका नेक्स्ट भी देखिए, बुलबुल मुंडा का, राइट, एकदम सेम है, एकदम मैकेनिकल तरीके से एक जैसा। और क्रॉस एग्जामिनेशन में आ रहा है कि और सफिशिएंटली हिंदुआइज मीन्स अगर आप ट्रांजिशन में भी है ना तो भी नहीं हो। बताइए सफिशिएंटली हिंदुआइज्ड
sufficiently Hinduized.
देखिए अब आपसे पूछ रहे हैं लास्ट सवाल, यहीं से जजमेंट चाहिए कि आपको वहां से। आपको दिखा दिया आपका एविडेंस और अपना माइंड भी बता दिया क्या सोच रहे हैं। Now it is absolutely your choice. I have no problem. Evidence आप डील कर देंगे हम फर्स्ट अपील में। I deal with all the evidence subject to whatever you have to say. ऐसे selective तो नहीं कर सकते। Whatever evidence you want to place, I will consider it. ये डिमांड कर करके हमको लिटिगेशन नहीं बढ़ाना है। सुनिए ना आपका सुनिए ऐसा आप आज टाइम मांग रहे थे, हम कल पोस्ट कर देते हैं, ठीक है?
परसों कर दिया
ठीक है परसों पोस्ट कर देते हैं। तो आप क्या आप करेंगे इसमें?
I will go through the entire evidences of the parties and will refer back to your lordship.
You want to argue? फिर उसके बाद रिमांड नहीं करेंगे, फिर हम सुनेंगे मेरिट पे, जो भी होगा मेरिट पे सुनेंगे।
हाँ ठीक है।
तो आप अपना एविडेंस भी देख लीजिए, क्रॉस एग्जामिनेशन सारा कुछ देख लीजिए, और आप भी अपना एविडेंस देख के क्रॉस एग्जामिनेशन देख लीजिए। और परसों जो है आप अपना थोड़ा सा रिटन नोट बना देंगे तो हम उसे कंक्लूड करेंगे, हो जाएगा? फ्राइडे लास्ट वर्किंग डे आपको क्या करना? अगर देखिए आपको मोटा मोटी हम सुन ही ली, अगर आप रिटन सबमिशन
एविडेंस हम भी पूरा गो थ्रू नहीं कर पाए थे तो
देखिए एक बात बता दें, सिर्फ रिटन नोट से तो नहीं होगा, आप इसको कल एक बार अच्छे से पूरा एविडेंस प्लेस करेंगे। जो भी चीज़ आपको पैराग्राफ इन पर्टिकुलर लगे हम लोग साथ साथ नोट करते जाएंगे, दैट यू आर रेफरिंग टू दिस क्रॉस एग्जामिनेशन दिस पैराग्राफ, वो हम लोग करते चले जाएंगे। उसके बाद हम इसको ऑर्डर को रिजर्व। लेकिन स्टोरी यही है कि यू हैव क्लेम्ड दैट यू वर सफिशिएंटली हिंदुआइज्ड।
that is our main case, but
That
at the
is your
same
main
time
case.
the evidence could not prove the custom that is also our case. उसके लिए भी
नहीं custom,
evidence-
you see as per the customary law you are not entitled is an admitted fact.
that is there.
As per the
They have to-
customary law you are not entitled is an admitted fact, but you say that since you are sufficiently Hinduized, therefore you are entitled for inheritance under, you are claiming inheritance under Hindu Succession Act,
Yes.
isn't it? You are not claiming succession under customary law. और आप रहते कहाँ हैं? Where are you staying, in your in-laws place or where are you staying?
हमारा केस है कि हम फादर के ही दाल में उनके प्रॉपर्टी पर हम शुरुआत से रह रहे हैं।
And you are a widow?
हाँ विडो, हस्बैंड के डेथ के पहले ही
तो
से
भी आपको कुछ तो शेयर मिलना चाहिए as a widow also when the property is being, if you are dependent on that. इस पे भी ध्यान दें to what extent you are dependent and whether you have proved
Father.
that you are dependent.
on father.
That's right. ना अगर मान लीजिए आप उनके ऊपर डिपेंडेंट हैं तो मेंटेनेंस का राइट तो आपको है ही ना, and if the property is being acquired then what will happen to your right of maintenance?
तब अगर तब इसको वेकेशन के बाद ही रख दिया जाए, हम लोग we will full pledged army.
Yes, Mr.
वो तो है that
उसको तो आप नहीं इग्नोर कर सकते ना,
अगर
मेंटेनेंस का राइट तो है ही,
मेंटेनेंस का
मेंटेनेंस का राइट तो है,
दैट
उसको तो आप कैसे डिनाई करें?
वो हम
अब कितना कॉम्पेंसेशन?
Compensation to the crores में है, around 6 crores.
3 crores something.
नहीं, 6 crores. अच्छा, 6 crores. 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 6
3 crore 18
नहीं ऊपर
Oh,
Is there
yes.
any need for giving any evidence on the quantum of maintenance? We can just
लाइफ इंटरेस्ट तो जो होता ही है
Life interest-
लाइफ इंटरेस्ट
it
होता है तो
cannot-
जितना दिन लाइफ रहेगा उतना ही दिन ना भोग करिएगा, उसके बियॉन्ड भी करिएगा।
अगर जमीन ठीक रहा है तो उसमें फिर अपोर्शनमेंट
नहीं ये तो एक्वायर हो गया ना जमीन,
हाँ
तो इसमें अपोर्शनमेंट होगा। लेकिन अगर आप एज अ मैटर ऑफ राइट क्लेम करिएगा अंडर हिंदू सक्सेशन एक्ट, द प्रोपोर्शंस आर डिफरेंट, बट इफ यू आर क्लेमिंग मेंटेनेंस then the situation is different. It's not that you are completely non-suited.
यस हाँ इवन अदरवाइज शी इज एंटाइटल्ड फॉर मेंटेनेंस आउट ऑफ द प्रॉपर्टी ऑफ हर फादर
तो ऐसा ये है कि नहीं कि मेंटेनेंस चाहिए?
ये ट्रीटेड नहीं है प्रॉपर्टी
नहीं
ये ट्रीटेड नहीं है, लेकिन हाँ ये ट्रीटेड है कि वो अपने फादर के प्रॉपर्टी पर
डिपेंडेंट
हाँ उस रह रही है शुरू से और वही उसका जीविका का
जीविका को
साधन है।
देख
हाँ
रहे
that is
ऐसा
that has been treated that has been तो इंटायर एस्पेक्ट पे वो जो हम लोग तैयार होके बातचीत कर रहे थे वो जरूरी डिसाइड कर रहे थे वहाँ जाने के बाद फिर दो
तो
चार
कल करिए फिर कि अब छुट्टी के बाद कौन देखेगा?
कल कल जो सब एस्पेक्ट पर फिर तैयार होने से होंगे फिर हमको जजमेंट भी देखना होगा मेंटेनेंस पार्ट जो है उसमें कुछ जजमेंट हो जाती है प्लेस में
तो हम जो 2:15 बजे से जो बैठ के सुन रहे हैं वो क्या मतलब ये सब तो आपको बेसिक चीजें हैं
तो
ना।
हम लोग उन्हें उस दिन रिफ्रेश कर देंगे कई टाइम में भी रिफ्रेश कर देंगे जिस दिन रखा जाए वो ऑन दी ओपनिंग डे भी रख सकते हैं कोई
अब मेरे पास बेंच रहेगा क्या गारंटी? देखिए प्रैक्टिकल चीज है, आप रिसर्च करने बैठे आप छुट्टी के बाद भी रखेंगे ना तो 2 दिन पहले ही फाइल होंगे, हम जानते नहीं है ये सब लोग चाहते हैं छुट्टी के बाद के 6 महीना बाद भी रखेंगे तो 2 दिन पहले ही फाइल होंगे।
नहीं हम तो वेकेशन में तैयार रहेंगे हम कहीं जाना नहीं
आप इनका नींद उड़ा देंगे क्या? कहीं नहीं जाइएगा तो ये बोलेंगे बैठ के हम इनका
हम बाहर जाना
कल थोड़ा थोड़ा बहस करिए छुट्टी के पहले से सुनिए, ऐसे नहीं करिए।
तो परसों ही रख दिया जाए जो हम लोग जो भी तैयार हो पाएंगे परसों ही कर देंगे एज फर्स्ट केस रख दिया जाओ
दिस विल बी द ओनली केस क्योंकि परसों 3:30 बजे से हम लोग का एक डीबीबी राइट है,
ठीक है तो
इसके अलावा कोई केस नहीं सुना। और भी कुछ रखेंगे परसों हम नहीं रखेंगे, कल ही बेल पे रखेंगे तो कुछ नहीं रखेंगे।
whatever happens, whatever be the result, I think he'll agree that your lordship it can be noted as partner because sufficient time we both have
पार्टनर
argued.
का कोई मायने नहीं है क्योंकि वंस द बेंच चेंजेस लगता है अब पार्टनर रहता नहीं। आई डू नॉट नो रहता है, अगर मान लीजिए कोई कोर्ट बोल दे कि पार्टनर है
फिर ये पूरा आर्ग्यू करना फिर एक ये में बहुत इसी क्या
आप परसों इसको
इतना
करिए।
टाइम
आप परसों कंक्लूड कर देते हैं
परसों conclude।
परसों conclude।
ठीक
Heard the learned counsel appearing on behalf of the parties, the learned counsel for the appellant has submitted that the matter arises out of Land Acquisition Act and there is dispute between the parties with regard to apportionment of the compensation amount. He submits that the appellants he submits that it was the specific case of the appellants hearing before the learned court that they are governed by customary law of the tribes of Mundas, and under such law the daughters / widow of the family have no right of inheritance, rather they have right of maintenance
maintenance only.
during their lifetime. He submits that the specific case of the respondent hearing before the learned court was that they are sufficiently Hinduized and therefore they would be governed by Hindu Succession Act. He has also submitted that it was never their case that under the tribes to which the parties belong, there would be inheritance upon the daughters/widow of the family.
Yes.
He has further submitted that since the respondent hearing claimed that they are sufficiently Hinduized, it was for them to prove that they were sufficiently Hinduized. And one of the essential rituals of Hindu religion is cremation. क्या बोलते हैं उसको?
Cremation by way of fire. Word
Funeral.
fire. E-Y-R-E.
हाँ.
E-Y-R-E.
Fire.
In fire. He submits that there is material on record to show that the family members of the parties were क्या बोलेंगे उसको? हाँ.
Warrior.
Okay. Were
Buried.
were buried after their death. He submits that the respondents hearing failed to prove that they were sufficiently Hinduized. However, while referring to the improved judgment, he submits that the learned court has mentioned the case of respective parties and have summarized the evidence of both the parties, but has not discussed the evidence nor any findings have been recorded as to whether the parties were sufficiently Hinduized so as to attract Hindu Succession Act 1956. He also submits that the judgment which has been followed by the learned court to hold that the parties would be governed by Hindu Succession Act does not apply to the facts and circumstances of this case, inasmuch as it applies under those circumstances where the parties have failed to prove the religion which they are following, and the principle of equity and good conscience will be attracted only under such circumstances. The learned counsel submits that the learned court has not at all discussed the evidences on record, both oral and documentary, and on the other hand has applied and has taken a wrong approach by deciding the case. The learned counsel for the respondent has submitted that there was enough material on record to show that the parties were sufficiently Hinduized, and the judgment has been however, he does not dispute that the evidences of the respective parties have not been properly considered. He further submits that it was required. He further submits that not only the fact that they are governed by tribal law, but it was also to be proved by the appellant hearing that under such tribal law there is no right to inherit the property so far as the daughters and widows are concerned. He submits that no instances in the society has been placed by the appellant's hearing to show as to how the property devolved in their family. And in absence of such instances, the learned court has rightly applied the principles of Hindu law by referring to the principles of equity and good conscience.
Yes, justice, equity, and
Justice,
good
equity and good conscience.
Hindu law.
At the request of the learned counsel for the parties, the case is adjourned for further hearing tomorrow. And day after tomorrow. And the learned counsel for the parties have undertaken to prepare short synopsis with respect to the materials placed on record by the respective parties, as apparently the materials placed on record have not been duly discussed by the learned court, and no specific finding has been recorded as to whether the parties are governed by tribal law of inheritance, where the females are excluded from inheritance, or they are governed by Hindu law, governed by Hindu Succession Act, as on the basis that they have been sufficiently legalized. तो आप आ जाइए परसों पोस्ट डे आफ्टर टुमारो एट 2:15 एकदम बढ़िया से नोट्स बना के लेके आएंगे और एक दूसरे को दे भी देंगे such that if there is any error और सॉफ्ट कॉपी दे देंगे सॉफ्ट कॉपी भी चाहिए हमको
Auto and Mason case item 14, first appeal 86 of 2024.
Where is the other side? Other side?
Only 7 days delay. Only madam was directed to madam subcommittee approved as to file. Only decision we don't have to file.
Sorry, you have filed it?
You have filed and administrated in para approved by subcommittee.
What do you have to say on the point of combination?
I have earlier raised an objection to which my lord has said not be more generous in not agreeing to my lord.
Heard the learned counsel appearing on behalf of the parties. IE number concern? IE number?
7143
7143
2025.
of 2025. The learned counsel for the applicant has submitted that the petition has been filed for combination of delay of 187 days, and the supplementary affidavit has also been filed to place on record as to why the delay in filing the petition for condonation. For filing the interlocutory application, he submits that the applicant, who looks after the case, was about 79 years old and was suffering from various ailments at the relevant time of filing the present appeal. As such, he could not come to the court to swear the interlocutory application seeking condonation of delay. However, subsequently, the petition was filed and the supplementary affidavit has also been filed. The learned counsel for the respondents has opposed the prayer for condonation of delay and has submitted that the applicant ought to have explained the delay in the petition for condonation of delay itself. And old age is not a ground for not taking appropriate steps at appropriate time. After hearing the learned counsel for the parties and being satisfied with the cause shown in the interlocutory application, read with the supplementary affidavit which has been filed by the applicant, explaining the delay in filing the appeal, the prayer for condonation of delay made through IN number 7143 of 2025 is hereby allowed. अब क्या करना है बताइए क्या मैटर है मनी डिक्री स्टे नहीं होता है हम स्टे नहीं करेंगे you are the sole respondent.
What they have stated, my lord. Here they have preferred an application for stay. In the meantime, they have approached the NCLT Calcutta for dissolving the company. They are not included as a party.
They will not be.
They are not disclosed the liabilities, my lord, of this, my lord, our liabilities pursuant to this decree. They are not disclosed there, and they are liquidating the company, my lord. I said, produce, my lord, the status report of the NCLT Calcutta, and here, my lord, they are asking for the stay. Here also they have not disclosed, they have approached the NCLT.
Now, moratorium has been declared.
But I have not been put to notice. Just
नोटिस नहीं आएगा आपके पास आपको नॉलेज हो गया आप खुद ही जाइए
Yes,
नोटिस नहीं आएगा वो पेपर पब्लिकेशन करके डिस्ट्रीब्यूट कर
नहीं,
देंगे
हम
जिसको भी
लोग-
ऑब्जेक्शन करना होता है दे वोट नो
yes. But on Procedural, I was today only I was going to.
क्योंकि आपका पूरा ही पैसा खत्म हो जाएगा 22 करोड़ है
Yes, and they suppressed this fact, my lord, before this honorable court also that they are going to dissolve this because of this liquidation only, my lord, they sought the amount from me, my lord.
This Xerox having auction this company.
sorry
Auction to the Xerox Limited having auction to
the property has been auctioned sold
this property is auction but it is Egyptian target the device to the
आपकी बात नहीं समझ आ रही
Today, this Xerox Limited, not about a lot of party. So that Xerox Limited has to be auction prior to only here parties because only has given some money and received some money.
सुनिए सर आप थोड़ा हिंदी में बोलिए आप भाषा नहीं समझ आ रही
So this Xerox
सूट किसने फाइल हुआ था for recovery of what amount
amount
22 crores
22 crores.
okay what was the dues for what was the dues for
There is no use for it. My
as per the plaint what was the dues
I have to play this for dues.
the dues was for what
As an investment in the company.
oh sorry so they are the investors to your company
Investment.
right okay now they wanted their money back
Yes, sir.
they filed money suit
Yes,
suit has been decreed
decree. Yes.
correct so they are the investors and the suit has been decreed and now you have gone to NCLT for liquidation
चेकिंग लिक्विडेशन का बात हो तो कहाँ से बोल रहे हैं हमको भी वेरीफाई करना पड़ेगा तो ये लोग जिसमें इन्वेस्ट किए हैं वो तो ऑप्शन
स्टे तो है नहीं वी डोंट केयर अबाउट स्टे तो होगा ही स्टे रिजेक्ट कर दें आपका मनी क्लेम है स्टे रिजेक्ट कर देंगे आई एम नॉट गोइंग टू स्टे इन
फिर फाइल हियरिंग की रिपोर्ट लगे आपको फाइल हियरिंग आफ्टर वेरिफिकेशन
कोटक महिंद्रा किस लिए आईडीबीआई किस लिए
ये लोन लिए थे बैंक से क्योंकि वो पूरा नहीं कर पा रहे थे इसी फ्रस्ट्रेशन में वो ऑप्शन होती थी उन्होंने कंपनी को ही बेच दिया इनिशियली इनसे हमारा कुछ क्लेम था मतलब बट अब सब खत्म हो चुका है बैंक से कोई कंटेस्ट नहीं है
and it is a suit for specific performance of contract
there was
yes the suit is for specific performance of contract
Yes, sir.
and in the alternative a decree of rupees 45
Yes,
crores.
that was one, but they instructed me, Lord, that if I pay the amount, my Lord, I will have the stake in the company. And if not, my lord, therefore I submit this alternative period for payment of the amount whatever I have invested. The court declined that specific preference cannot be granted. Therefore, my lord, the amount which I have invested will not have been granted.
So the argument for estimate, right now I am not placing it so.
The learned counsel for the appellant submits that he does not want to place the interlocutory application seeking stay of the money. Accordingly, the same is dismissed as not placed. अब कब करिएगा बताइए? Record आ गया इसमें? You are also there, Mr. Patel.
Yes, my IE was there for deletion, that has been rejected. I was
With the consent of the learned counsel for the parties. Post this case for final disposal. Choose करिए अपना date.
Last week of June.
30th of June. Parties to prepare synopsis, list of the synopsis of arguments and the judgments specifically related. Particularly, the matter arises out of specific performance of contract.
And money suit.
Money suit. Or the specific performance of contract / recovery of money.
Fifth case for hearing item 32, the PL 2071 of 2012.
What is it? 33C2.
33C.
What do you want?
So I want that the others to be satisfied.
At best you can vote this only.
Sorry brother?
अब आप ये तो litigant की तरफ से बोलो, advocate की तरफ से बताइए क्या चाहते हैं?
अच्छा एडवोकेट की तरफ से ये जो ऑर्डर हुआ है, this is for payment of arrears of money. While he was under employment of the erstwhile employer, 1969, this is for the period. 72-79. This is filed sometime in the year 2008. And the award passed by the tribunal is, once a reference was made and the award was passed on 27th November 1975. And the reference was whether the action of the management of Dharmabad Colliery POs so-and-so in stopping work of 76 workmen named in the schedule attached to this award is justified. And the award was to sum up, it is held that the stoppage of the workmen by the old management is unjustified. There were records.
Let us see the award.
Yes.
And who was directed to pay the award?
payment was to be made by the old management till the time the management of the coal mine is there. And for the rest period, I was directed. So this direction was passed in 1975. Kindly see that. The operative portion of the award,
Para 28.
para 28. To sum up, it is held that the stoppage of the worker by the old management was unjustified. They will be deemed to have continued in service, and the old management shall be liable to pay all back wages till the date the ownership and management were with it. The new management, that is Bharat Coking Coal Limited, shall within 1 month of the publication of the award be liable to reinstate all these workmen and provide them with suitable jobs with continuity of past service and its consequent benefits in gratuity.
So what is the cut-off date?
The cut-off date as per me is 1/5/1972, paragraph 18. Paragraph 18 of the award.
Yes.
This brings us to the question whether the relief of reinstatement can be granted. The past owners are now out of picture. After the nationalization of coking coal mines, and they are unable to reinstate these workmen. The government company Bharat Coking Coal Limited, which has replaced the past owners since 1/5/1972, claims by virtue of section 9 of the Coking Coal Mines Nationalization Act absolute protection. So this is 1/5/1972. So as per the award, what would be payable would be from the period 1/5/1972 onwards. As per the workman, he joined.
That is what that has been awarded. 1/12/1972
No, it
to
is
24/5/1979. This has been awarded.
1/5/1972 is the date when we take over.
That's
That
right.
is the date of nationalization of coal mine.
Yes.
So it would be from 1/5/72, and that is the period for which it has
1/5/70.
1/5/72.
Yes.
And that is the period for which it has been granted.
It has been granted from 1/12/12/1. 12/1.
4 months.
12 months cannot.
4 months in
4 months difference.
4 months difference.
उसको तो कट जाएगा।
हाँ, उतना तो
उतना कट जाएगा।
ठीक है।
So because it is nationalized on 1/5/72 and more
ये
what
12/1 का डेट कहाँ से लेके आए?
ये हो गया नेशनलाइजेशन होगा
1/5/72
Nationalized on 12/1/1972.
1/12 to 72 में nationalization.
इसी में लिखा ही हुआ है.
पैरा
There is a finding to
No,
that
this is
effect.
12/1/72 cannot be because the act has come into force on 1/5/72. So this is one part.
Nick,
What is
you see, act coming into force and actual date of takeover means
that is the date of takeover. That is the date of takeover of the coal mine by the petitioner company.
बताइए 4 महीना का आपका अमाउंट ये आपको क्या बोलना है?
4 महीना तो will make hardly any difference. It can
That
be
will be
taken.
sufficient. हो गया बस.
हाँ हाँ, लेकिन दूसरा जो मेरा मेन पॉइंट ये था कि दिस पर्सन who has filed, he is the only person who filed. This filing is after he retired. He came into my employment. He worked till
अब ये मत बोलिए कि टाइम वार्ड हो
2028.
रिटायरमेंट के बाद कहीं दिया तो क्या ही हो क्या स्टे हो गया इसमें?
नहीं
Seriously contest भी नहीं हुआ.
फिर पीरियड कब का?
A period is back, but it was not seriously contested on the ground of delay.
छोड़ दीजिए उसमें कुछ नहीं है ठीक है.
And this man is probably missing there also.
Yes, I am the amicus because the notice also returned. No, I have not sent the notice, but the notice went from court and it has come with the note that
Not
he has
available.
left, not traceable.
And then I was
Yes,
appointed.
What, that's all.
Yes. And the interest part.
Interest to that.
Yes. Interest would.
बताइए amicus. Interest के लिए क्या
Interest is from the date of the order.
In default 8%.
In default it is.
तो in default तो certificate proceeding का interest मिलेगा.
In default मिलेगा but
In default.
today we don't even know whether there can be a claim. But
हमने
that
तो ये
is
decide कर ही लिया ना कि this interest cannot be awarded. वो क्या हुआ है? LPA में क्या कर रहे हैं आप? कुछ नहीं कर रहे. LPA हुआ है क्या?
on this issue.
On this point of interest.
No. But there are some conflicting high court judgments.
तो आप करते रहिए conflicting चीफ जस्टिस के पास जाके आप प्रेजेंट करिए.
There are some-
Conflicting हो गया इसका full
Bombay High Court has said recently that interest can be awarded in 33C.
बॉम्बे हाई कोर्ट
Allahabad
में
High
झारखंड
Court
हाई कोर्ट का
says-
जजमेंट प्लेस किए गए.
Allahabad High Court says it cannot be awarded.
We are concerned with our jurisdictional high court. यहाँ का जजमेंट तो आप प्लेस नहीं करते. प्लेस करने से भी एडवोकेट लोग प्लेस नहीं करते.
नहीं यहाँ का एक in one case so far as here also it has been ordered that although I don't know if it is reported, it's a recent judgment that interest has probably been given for some period in the BRS.
BRS मैटर ना. BRS का बात दूसरा है. This is a
BRS that there
certificate
was
proceeding.
gratuity was not paid, so delayed
This is straight
gratuity
away a
was paid.
certificate proceeding, realizable through certificate proceeding. We are the learned counsel appearing on behalf, learned counsel appearing on behalf of the petitioner and learned amicus appearing representing the private respondent. As per the records, the private respondent could not be traced out, and consequently an amicus was appointed by this court. The learned counsel for the petitioner, by challenging the impugned order as contained in Annexure 3 passed under Section 33C(2) of the Industrial Disputes Act, whereby the private respondent claimed an amount of rupees 70,900 being the dues for the period from for the period from 7/4/1969 to 24/5/1979. The learned counsel submits that the background of the case is that an award was passed in reference case number reference case number 23 of 26 of 1970, wherein the terms of reference was inverted comma whether the action of the management of new Dharmaban Colliery PO Malkhera district Dhanbad is stopping from work 76 workmen within bracket named in the schedule attached to this award bracket those is justified. If not, what relief they are entitled to. He submits that as per paragraph 18 of the award, the cut-off date on which the petitioner had taken over the colliery is 1/5/1972, and as per the final award order passed in the award, it has been held that the present petitioner would be liable only after the takeover of the management of the colliery, and the liability with respect to the previous period was with the previous owner. He submits that the learned court, while passing the impugned order, has taken the date from 12/1/1972 instead of from 1/5/1972, and liability has been fixed. And he further submits that the interest upon default in payment of the amount awarded could not have been directed in view of the order passed by this court in WPL number 6969 of 2017. कल वाला फिर से दे दिए क्या?
वही that is ये main case है, उसके बाद follow आपने बहुत सारे ने किया है, ये exhaust para 29 इसका नाम है.
And is referred to paragraph 29 of the same judgment.
Last two lines.
The learned counsel for the petitioner has also submitted that the claim itself was made after a long gap. The learned amicus has submitted that no objection was apparently raised with respect to delay. Otherwise also, the delay will not defeat the right of the concerned workman. So far as the cut-off date is concerned, it is not in dispute that the petitioner had taken over the management only from 1/1972. On the point of interest, the learned counsel has submitted that other high courts have taken different view. However, the order passed in WPL number 6969 of 2017, which has been placed by the learned counsel for the petitioner and the ratio laid down therein is not in dispute. After hearing the learned counsel for the parties and considering the short submission, the period for which it is not in dispute that the petition under section 32C2 was filed after the award passed in reference case number 26 of 1970. The claim was for a period from 7/4/1969 to 24/5/1979. However, the learned court has given the award from 12/1/1972 to 24/5/1979 by treating the date of nationalization of the colliery with effect from 12/1/1972. Although as per the award passed in reference case number 26 of 1970, the petitioner had taken over the management only from 1/5/1972 and the liability of the petitioner was accordingly fixed. In such, the learned court has not taken into consideration the aforesaid finding of the learned Central Government Industrial Tribunal by passing the award in reference case number 26 of 1970. Consequently, the period for which the award has been, the impugn order has been passed is confined to the period 1/5/1972 to 24/5/1979. इसको कैलकुलेट करना पड़ेगा क्या? And the amount will be accordingly reduced. And so far as the interest is concerned, there is no question of award of interest in view of the judgment passed by this court in WPL number 6969 of 2017. This petition and accordingly the award of interest is also satisfied. This petition is disposed of with the aforesaid modification of the impugn order. Appreciation of amicus डाल दीजिएगा and please raise your bill. I request you please raise your bill, whatever be it.
I have not raised it now in any case.
You see,
Because I
the
have
state
worked
is
with
not
this.
bankrupt. The state is not bankrupt. It's something, it's a kind of आप बिल रेस करिए उसके बाद जहाँ मन होता है लेकिन बिल रेस कर दीजिएगा, otherwise this money will go to the state क्या फायदा है?
Only appeal is there. First appeal remanded by Supreme Court that matter is.
Oh, I have to sit again.
No, not for sitting. Only it may be placed tomorrow.
उसमें क्या हो गया?
Only a future date would be fixed. That is the only for that.
Okay.
And my